Hello, everyone. Thank you so much for joining the 6th episode of the ECGI Spotlight Series. I'm Geeyoung Min from Michigan State University School of Law, and I'm one of the co-organizers of the series. I'm delighted to introduce three distinguished scholars today. So Professor Kristin van Zwieten at the University of Oxford will present her work titled Bailouts and Bail-ins Are Better Than Bankruptcy, joined with Professor Horst Eidemüller at the University of Oxford and Professor Oris Sussman at the Side Business School in Oxford University for about 30 minutes. After the presentation, Tony Cage, a professor of law and economics at the University of Chicago Law School, and Aurelio Gurrea-Martínez, assistant professor of law at Singapore Management University, will comment on the paper for about 7 to 10 minutes respectively. Professor van Zwieten, the floor is yours.
Thank you so much, Professor Min, for the introduction, and thank you to ECGI for organizing this event and for all the work that goes into that. And thanks, of course, especially to Professor Casey and Professor Gurrea-Martínez for agreeing to be discussants for today. I'm really looking forward to their comments and, of course, any comments and questions from all of the audience members that are with us live. So thank you very much for being here. I'm really happy to have the opportunity to present this paper to you, a paper that, as Geeyoung said, was written with two colleagues at Oxford, Horst Eidemüller and Oris Sussman. Before I present this paper, just a little bit of context. There we go. Just lost my slide for a minute there. So this is a paper that was written in UK lockdown 1, early 2020, early to mid 2020, a period that I think it's fair to say was considerably more productive for me than UK lockdown 3. This makes it an early pandemic paper. And in the last week, I've been discussing with Horst and Oren whether we would write this paper differently now with the benefit of what we now know about the duration and other features of this pandemic. And the short answer to that question is no. We don't think we would, although we're more cognizant now about the difficulties of operationalizing some of our prescriptions than I think we could have been at the outset of the pandemic. This paper forms the foundation for a wider project that I'm doing with Horst and Oren called COVID-19 Public Policy and Commercial Law, in which we're seeking to understand how policymakers intervened in response to pandemic-related business distress and with what effects. And so we've had a team of research assistants working to gather evidence of the policy response to COVID-19 related business distress in a range of jurisdictions. They've so far done a detailed analysis of the public policy response in over 25 jurisdictions. And at the moment, we're working on classifying and coding those responses. But I can already say that it's clear from the early work that we're doing with these data sets that it's clear that some common themes are the complexity and to some extent the opacity of the public policy response. So in terms of complexity, if you look, for example, at the work done by our team on the Spanish or the German response to COVID-19 related business distress, our RAs uncovered over 50 policy interventions directed to business distress in the first 6 to 9 months at the federal level alone in Germany and Spain. So it's a highly complex policy response, and that's a theme across the jurisdictions that we have looked at. So this paper is largely theoretical in orientation, and it is a response to an expectation and an observation. So the expectation was simply that we can realistically expect mass bankruptcies across multiple sectors of the real economy to follow any significant period of a trading shutdown. And the observation was that we could see very early on in this pandemic, policymakers moving with remarkable speed to offer, in many cases, unprecedented forms of relief in apparent response to a perceived risk of mass business bankruptcies. In this paper, in writing this paper, we were interested in better understanding what the case for intervening was, whether there was a case for a public policy response to COVID-19 related business distress, given the obvious question, isn't that what bankruptcy's law is for? So what is the case for an additional public policy response? So we're interested in understanding that question. And assuming there is such a case, we were also interested in understanding the forms of intervention available to policymakers and the principles that are or should be relevant to choosing between those possible forms of intervention. Now, I said assuming there's a case for a public policy response, but I think it's fair to say that in beginning this paper, we had a clear hunch, if you like, or grounding intuition that bankruptcy law was a poor candidate for the treatment of COVID-19 related distress. I think initially we had this intuition because of our experiences of poor functioning or poorly functioning bankruptcy procedures around the world, and a concern about inflicting the significant direct and indirect costs associated with the use of those procedures on the cohort of newly distressed debtors, some of which might be perfectly capable of being returned to solvent trading on the end of a lockdown, let's say. So initially, I think our concern was about poor functioning procedures and the infliction of significant costs associated with their use on a large cohort of debtors. But as work on the paper progressed, we became firmly of the view that even in jurisdictions where there was a well-functioning bankruptcy regime, we thought that the features of those regimes made them a very poor fit for the treatment of the particular features of COVID-19 related distress. That's a point I'll come back to. So in the first part of the paper, we look at the case for a public policy response, or the case for policymakers to intervene in response to COVID-19 related business distress. And the starting point for this part of the paper is the fact that revenue losses flowing from a period of a trading shutdown are irrecoverable. No public policy response can recover those. But the case for a public policy response lies in understanding how this initial unavoidable loss is amplified, absent intervention from the state, by the costs of financial distress. So the building blocks for this amplification argument, which is in the first section of the paper, are essentially as follows, and I hope this is fairly intuitive. In a perfect world, market participants would have bargained to buy and sell protection from pandemic risk, and that would have resulted in a more even distribution of COVID-19 losses. In the absence of such trade, we will expect losses to be disproportionately concentrated in some sectors. Now, when we wrote the paper, we didn't have a sense of how much of business turnover loss would be covered by business disruption insurance, which of course is a turnover-based insurance product. But now with the benefit of hindsight, we can say that it was safe to assume a general absence of such trade, or at least the absence of business disruption insurance sufficient to cover these losses. For example, the most recent estimate from the relevant European body estimates that 1% of losses globally in 2020 will be covered by business disruption insurance. In the absence of such trade, then, again, we expect losses to be disproportionately concentrated in some sectors. Now, this is the crucial point. The losses in those sectors in which losses are disproportionately concentrated, will not just net out to zero with equivalent equity gains in the sectors that do well during a period of a trading shutdown. For example, Zoom, the platform on which we're running this event. And that's because of the costs of financial distress, costs that are additional to the initial unavoidable revenue loss. So you concentrate revenue losses in particular sectors, and that pushes some debtors or all debtors in that sector into financial distress. And that financial distress is itself costly. And that is the amplification effect with which we're concerned in the paper. The additional cost over and above the initial unavoidable revenue loss that no public policy response can recover. Notice, and this again is a very important point, that the amplification effect is not confined to businesses with financial creditors. It is perfectly possible for businesses that have no external debt finance to be pushed into financial distress with all of its associated costs during a lockdown. And that is because most businesses will have fixed operating costs that accrue periodically under executory contracts. And in the absence of revenue, as where you're disabled from generating revenue during a lockdown, those obligations that periodically accrue, for example, under a lease or under a contract of employment, those obligations will continue to accrue. And in the absence of revenue, unless you have cash reserves sufficient to continue to pay those obligations, or unless they're discharged, for example, by the operation of a doctrine of frustration or some other form of relief, then you can be pushed into a situation of financial distress without any external debt finance to begin with. So the amplification effect is not confined to debtors who have borrowed prior to the onset of the pandemic. And it's this amplification effect that we say forms the basis of, or the case for intervention by policymakers. Now, the obvious objection, what about bankruptcy law? Isn't bankruptcy law, and more specifically reorganization law, the proper route to delivering relief from financial distress for newly distressed debtors in the pandemic? Well, of course, it's right to say that many jurisdictions do offer a form of bankruptcy procedure under which liabilities can be written down or otherwise compromised non-consensually under the protection of a stay with a view to restoring the debtor to solvent trading. So the obvious question is, in a jurisdiction where there is such a procedure, and more specifically in a jurisdiction where there's such a procedure that functioned well prior to the pandemic, by which I mean a procedure which functioned cheaply to relieve debtors of part or all of their liabilities in circumstances where a restructuring would be value maximizing for claim holders. In such a jurisdiction, why not just use such a procedure to offer relief against COVID-19 induced financial distress? Why is an additional public policy response necessary? Well, here are some difficulties that we perceived with relying on the pre-pandemic bankruptcy law. First, most obviously, 1/3 of economies don't have a reorganization procedure, at least according to World Bank 2020 data. Now, of course, those economies will have other forms of collective insolvency procedure, but in our view, other types of insolvency or bankruptcy procedure, and in particular, procedures that resolve distress by forcing a quick realization or conversion to cash of assets, by forcing a quick sale to a third party, are likely to be a very poor substitute for a reorganization procedure if the objective is to minimize the amplification of the shock. So we make the case in the paper, drawing on seminal work by others, for why we think forcing debtors into quick realizations is likely to further amplify the shock by producing sales at less than fundamental value, or fire sales, rather than help to ameliorate or mitigate the amplification of the shock. So we don't think these type of procedures are going to be a good substitute for a procedure that's designed to enable the business to stay with the debtor with a reduced debt burden, that is, a reorganization procedure. So 1/3 of economies don't have one. That's our starting point. But of course, plenty of jurisdictions that do have reorganization procedures don't have reorganization procedures that function well, even in normal conditions. And in my view, this is unsurprising because reorganization procedures are highly complex in design and highly complex to operationalize. So all of the features that are characteristic of reorganization procedures make them very, very difficult to operate and implement in the real world in ways that ensure they continue to be value maximizing for claim holders. So plenty of jurisdictions with reorganization procedures are not jurisdictions in which we'd want to subject a large cohort of newly distressed debtors to treatment by such a procedure. Well, what about jurisdictions where there is a well-functioning reorganization procedure, a pre-pandemic bankruptcy law that worked well in reorganization cases? Well, we might have a concern about institutional capacity. This is something that others wrote about at the beginning of the pandemic. So we might query whether there's the infrastructure to be able to offer mass treatment. But in our view, the more fundamental problem is that reorganization procedures by design are a poor fit for the treatment of COVID-19 related distress. And we say this because in our view, reorganization procedures are characteristically geared towards restructuring financial debt, and they characteristically assume that the debtor will continue to meet operating costs during the pendency of the procedure as a condition of being able to be permitted to continue to trade under the protection of a stay or a moratorium. These procedures are geared towards restructuring pre-commencement financial credit and assume the debtor's ability to continue to meet its costs while it's permitted to trade under the protection of a stay. Now think about the characteristic features of a lockdown bankruptcy. You may have a debtor, for the reasons I've already explained, who has no financial creditors at all, but is nevertheless still financially distressed as a result of periodically accruing obligations, operational costs under executory contracts. Moreover, if that debtor is prevented altogether from trading, as some sectors were in every lockdown, they cannot generate the revenue sufficient to discharge those operating expenses, which would normally be expected to be discharged during the pendency of a reorganization process. By design, these are not procedures that fit the weird, peculiar characteristics of COVID-19 distress. Well, what about debtors that do have financial creditors and for whom we think some restructuring is likely to be necessary, at least in relation to the financial debt? Surely we would contemplate putting those or that cohort or subset of the cohort straight into a reorganization procedure. Well, even here, we didn't think that this was desirable. So the duration of a lockdown, or as it turns out, multiple lockdowns, is not knowable at the outset. And it's also not clear exactly how that debtor's business model will be affected by the pandemic on exit from the lockdown. So in our view, given that the use of a reorganization procedure involves significant direct and indirect costs, even in jurisdictions where these procedures work well, it would likely be better to wait until at least the end of a lockdown period, where we'd have better information about the effect of the lockdown on the debtor and on its business model, because in our view, that better information would improve prospects of a workout and therefore save the debtor from having the direct and indirect costs of the process being unnecessarily inflicted on it. Now, I mean, if reorganization law doesn't look very well tailored to cure COVID-19 related distress, can't we just fix it so it's better tailored to do so? Well, clearly we can. So we can, for example, relax the requirement that a debtor sheltering in a reorganization procedure has to pay operating costs as and when they fall due as an expense of the process. We could also, in a bid to reduce direct costs, reduce some of the safeguards that are characteristic of reorganization procedures, such as judicial control, other forms of judicially administered safeguard. But in our view, this is a really, really bad idea because it risks distorting pre-pandemic bankruptcy law so that it's better suited to COVID-19 conditions, but less well suited to post-pandemic normal conditions. And that we thought was likely to reduce costs for all debtors as we exit from the pandemic. So a major concern we had in writing this paper was with distorting pre-pandemic bankruptcy rules in ways which will be prejudicial for our universe of debtors in a post-pandemic period. So if we're not going to use reorganization law, then what can we or should we use? How can policymakers intervene outside bankruptcy law to minimize the amplification of the shock, which, as we said, is the case for intervening? So in the paper, we talk about two different modes of relief, bailouts and bail-ins. So when we talk about bailouts, we mean it in exactly the way that Tony has described it in one of his papers. That is some transfer from the state to a private agent in order to enable that agent to pay their creditors or counterparties. By bail-in, we mean a one-time order to creditors or counterparties or some class thereof to forgive. And we didn't think about bail-ins because of the presence of bank resolution bail-in powers, which are quite different to the type of bail-in we have in mind, because bank resolution bail-ins have some predictability associated with their application from the outset. So here we're talking about an unanticipated order from the state to creditors or counterparties to forgive. And our motivation for thinking about this was a paper by Randall Krosner on the abrogation of the gold clauses in a congressional order of 1933 on moving away from the gold standard. So it was this paper that got us thinking about whether or not some equivalent would be possible in COVID-19 conditions. In our view, as we explain in the paper, either bail-ins or bailouts or some combination thereof could be used to, as we term it, stop the economic clock during a lockdown, so that a business prevented from trading during a lockdown could emerge in the same financial shape or the same financial condition as on entry. So what do we mean by this? Well, if we take the case of a bail-in, what we term a full bail-in, we don't by this actually mean a full bail-in in the paper, because we're quite clear that the state shouldn't order that employees have to forgive wage obligations. So we're clear in the paper that the state should intervene in the form of a bailout when it comes to wage liabilities. But if wage liabilities were assumed by the state in the bailout, then apart from this, a full bail-in would involve the economic clock being stopped by a mandatory write-down of all interest, lease, and license payments that accrue during the lockdown period. Now, if the business was not already in default prior to the lockdown, you shouldn't need a moratorium or a stay to do any additional work for you. So the work should be done by the mandatory write-down to restore that debtor from a circumstance in which they'd otherwise be financially distressed or at risk of financial distress. You shouldn't need a stay to do any additional work, provided, however, that any acceleration clauses in financial contracts are prevented from operating so as to bring forward the maturity on financial debt. But provided you disable acceleration clauses, this should be enough to enable a debtor to exit from a lockdown in the same financial condition as it was on entry. And what's important about this is that such an intervention draws a clear distinction between obligations already accrued prior to entry into a lockdown and what we regard as the problematic source of liabilities, that is those that accrue and continue to accrue throughout the no trade period where you can't generate revenue. Now, of course, you could use a bailout to achieve exactly the same thing. The difference is in who pays for the relief and how it's allocated, the cost of the relief. So in a bail-in, the cost of the intervention is allocated upfront to existing creditors and counterparties. Now, we don't, as we explain in the paper, anticipate stopping this at the first stage, but instead anticipate for this to be effective, the bail-in would need to be passed through. And this is the bit that we may want to talk about in discussion, the tricky bit, I would suggest, to be passed through so that in the end, the cost of delivering this relief is borne by the ultimate current savers in a system. In contrast, a bailout involves the cost of the intervention not yet being allocated. It's going to be borne in the future by taxpayers, but exactly how and who is not yet known. And that's the essential difference between relief in the form of a bail-in or in the form of a bailout. Now, one of the comments that we received from a number of people in response to early versions of this paper was that providing relief in either of these ways risked preserving non-viable businesses for longer than would be likely if businesses were simply subjected to immediate treatment by the prevailing pre-pandemic bankruptcy law. So does relief in this way risk preserving non-viable businesses for longer than if the pre-pandemic bankruptcy law had simply applied? I think the answer to that is undoubtedly yes. We view this as the price of delivering relief against the amplification of the shock for viable businesses. But in a perfect world, with perfect information, policymakers would tailor the relief to avoid this problem. Bail-ins and bailouts, as we say in the paper, are second best policies in a world of imperfect information. So I think the answer to this question is yes. So in the paper, we compare relief by bail-in and bailout with bankruptcy in a number of different ways, or using a number of different measures that you can see on the screen. Intensity of the intensiveness of use of legal resources, effect on the borrower, who pays, transparency in the process, longer-term effects on insolvency law, and cross-border effects. And we conclude that full-scale bail-ins or bailouts have, in our view, significant advantages relative to bankruptcy law. But we concede that the position is more complicated if the intervention is less than what I've termed a full-scale intervention. And I'll come back to that point in a minute. And I am coming to the end of my slides, Geeyoung, I promise. In our view, bankruptcy law only really has a natural advantage in relation to Measure 6, cross-border effects, at least compared with bail-ins. So what we would worry about with bail-ins is whether or not the bail-in would be recognised and treated as effective outside of the jurisdiction in which the order to forgive is made. We don't have that concern with bailouts because the liability is simply assumed or discharged. And we don't have that concern typically with bankruptcy, at least if the bankruptcy process is opened in a jurisdiction in which the debtor has their centre of main interests. It's likely that relief given under such a procedure will be recognised and treated as effective abroad, at least in most systems, except perhaps in the peculiar English courts. Second last slide. What principles should policymakers use to make a choice between bail-ins and bailouts and in designing relief by way of bail-in or bailout? So this part of the paper, which is the final part of the paper, is very tentative, but these were the 5 principles we suggested. A principle of proportionality, not going beyond that which is necessary to achieve the stipulated goal. A principle that protection against the amplification of the shock should be delivered at minimum cost, including the costs associated with long-term distortions to settled contract and debtor-creditor law. A principle that transfers should be from the less financially constrained to the more financially constrained. A principle that policies should be designed to fit the institutional framework within which they're delivered. And a principle that the process of allocating the cost of intervening should be as transparent as possible. How well did policy makers live up to these tentative principles? That's a topic for another presentation, but I can just say briefly that I think on transparency, there's a real difficulty because of the way in which policies were implemented and because of the branches of government that were responsible for implementing and delivering relief. Very high degrees of opacity can be observed at least in the jurisdictions that we've looked at. I think policymakers have attempted to fit policies to institutional frameworks. So I don't see much evidence of transplants of policies. They do seem to be designed with the particular features of the sectors to which they're targeted in mind. Proportionality, well, here I think that overall, my guess is that the conclusion will be policymakers did not go very far. And so in many cases, the forms of relief that we observe are ones which don't do a lot more than extend maturity. So they don't do much more than extend the maturity of liabilities that will accrue during a lockdown. So does that go beyond that necessary to achieve the stipulated goal? No, in one sense you can say that's proportionate, but does it actually do the work of minimizing the amplification of the shock? I'm doubtful. I'm doubtful that policies that merely extend maturity will actually achieve the underlying policy goal because they leave all of that debt on the balance sheet to be dealt with somehow in a future period. In conclusion, no public policy response can recover revenue lost in a period of a trading shutdown, but states can intervene to minimize the amplification of the shock that flows from the imposition of the costs of financial distress on previously solvent, perhaps even entirely debt-free businesses. In our view, at the onset of the pandemic, there was a clear case for intervening, even in states in which there was a well-functioning reorganization procedure capable of restoring financially distressed but viable businesses to solvent trading in normal conditions. There was a case for an exceptional public policy response. The questions that I think we have to ask now are, did those interventions go as far as was desirable? And could relief have been offered more cheaply and/or more fairly? Thank you very much, Geeyoung, and over to the discussants.
Thank you so much, Professor Van Zwieten. And this time, Professor Tony Cage and Professor Gurrea-Martínez will comment on the paper.
Thanks, and thanks, Kristin, for a fantastic paper. I think this is very well done and very important to think about how we address, this particular type of kind of systemic crisis and systemic distress, and what the right tools are. So I think the authors should be commended for having like the first really well thought out answer to that question. So my comments will be basically what I agree with, and then a couple of points where I want to push a little and have less optimism about certain things. So I agree 100% on their assessment of bankruptcy. During kind of last summer, thinking about this, I came to a similar conclusion for slightly different reasons, but if you put them together, there's a lot of arguments against bankruptcy as the tool here. One of the things they note that, like, if you change bankruptcy law, you're going to distort bankruptcy law in their normal functioning system. That's a great point. I think it's absolutely true. They point out that you're going to be administering it to firms generally with debt and not other firms, so you're not getting everybody. So that's not the way you want your solution to necessarily be implemented. I would add that it distorts all kinds of things like who files for bankruptcy. So normally you file for bankruptcy if you, the individual firm, has the need for it. But if the only way to get a bailout or some sort of rescue mechanism is to file for bankruptcy, you're now going to file when you otherwise wouldn't. And conversely, if the cost to getting the relief is filing, some people might not get the relief who really should. And so those distortions are really unnecessary. And I think that's a bunch of problems that the bankruptcy solution proposes. And more fundamentally, like, bankruptcy is a Chapter 11 in the US, reorganization systems in other jurisdictions. They are systems about dealing with specific debtors' financial distress. They're not great at dealing with systemic distress because, like, the judge handling the case doesn't know all of the factors the way maybe an agency or a central bank or executive branch might. And so it's a weird tool to deal with a systemic problem. So I'm 100% on board with that's the wrong tool here. To be clear, people will file for bankruptcy debtors will file for bankruptcy, and it should be functioning. We want to make sure it can handle the individual financial distress that's coming its way, but it's not the tool for solving the bigger problem. I also agree, excellent point they make, that I think it's kind of obvious, but a lot of people miss. You can't get the revenue back. Like, this is not accounting. This is stuff wasn't produced. It will never be produced. And therefore, our solution isn't trying to make goods out of thin air. It's trying to make sure the impact doesn't spread and doesn't get worse than it otherwise would be. And that's really important in thinking about the right solution. So that leaves us then with, all right, we want to solve a problem for all firms, not just firms with creditors. We want to solve a problem that's systemic. And what is the best tool? And they give us bail-ins and bailouts. I think that's the right tool set. They also give us principles for implementing it. I have no objections to the principles. They make perfect sense, right? You can think of it, want to do it efficiently, fairly, competently, transparently. Their principles add up to that. All right, so here's where I disagree a little bit, although I'll backtrack at the very end. My disagreement is between the two, optimism about bail-ins. I'm fairly skeptical that those are the better tool than bailouts in many circumstances at all. But again, I'll backtrack a little on that, but that's my starting point. So bail-ins, I think it was like government mandated stimulus, right? All right, you, this entity, you're going to provide stimulus to this other entity, and you have no choice to do it. Generally, I think those will be implemented on a case-by-case basis, or at least objected to on a case-by-case basis, like bankruptcies. And so now you're saying, all right, we're going to do this one case at a time. That adds administrative costs. And you might say, no, there's a blanket bail-in. But as the paper noticed, people will challenge that in court. And so you'll have judges being the ones to implement a systemic bail-in policy. And again, judges aren't necessarily, or you could say administrative referees, they're not necessarily the right entity to think about the big picture, like a central bank or a Treasury Department or an executive branch. But more fundamentally, I think bail-ins will be very complicated. And to their principle number 3, you've got to make sure you're shifting risk the right direction to the right party. That's a hard question. And if you get it wrong, you could have things backfire. So I only have 2 slides, but I'll kind of get to what I mean when I talk about that. So if you think about what they want to do in a bail-in, you have this small business that has the distress. Now, where are they going to get relief? They're going to get it from their landlords, and I'm simplifying here, also they're at banks, but basically they're not going to have to pay the bills that are due. All right, but, and absolutely correctly, Kristin says, well, wait, the landlords are in distress as well. So we're going to say they don't have to make the payments to their financial institution, right? But we're now we're putting out little fires, and we're moving the fires up the chain, and we're moving it toward the center of the financial system, and we risk turning a kind of economic problem at the small businesses into a financial 2008 kind of thing. So we can't stop there. We have to push that up to the investors, and they say, use the pension funds as your institutional investors, and ultimately that means the saving households are the ones who are going to bear the risk. Which I do agree that ultimately that's where you want this to lie, because society's got to deal with lost revenue. Someone's got to bear it. We want to spread it out. It's like insurance. We're going to do it to those who are, broadly the people who have savings. All right, so that's complicated because you keep pushing it up and up and up, and you have to do it when the small business says, I want out of my contract, et cetera. So let's just think, and then one other thing. All right, that doesn't even solve every problem. And this was noted, the workers, right? So they have to be paid, I think, in any kind of reasonable system. So they're going to need a bailout of some sort. Now, what about the suppliers that the business is no longer buying from? Well, we're going to treat those, I think, just like another small business and bail them in, go back up the chain. Now let's compare what a bailout would look like. So a bailout, instead of having all these different points of entry with this small business, this landlord, a bailout usually could be done where the government gives money to financial institutions and tells them to put that money out in loans and grants and forgiveness to the landlords, the suppliers, the small businesses, all of those entities. Use your institutional structure to get the money out. We'll separately send stimulus checks to workers. And that's kind of it, right? That's the bailout. And that seems to me a lot easier when you're trying to do something in a crisis. Their main objection, which I think is absolutely right, is who pays for that? Not us, future generations. We build up national debt, that can be a problem. Now, my only pushback there is that's only a problem because of the way we do things. And if we're talking about designing a system, well, we could say, all right, households pay for it. Now, we could tax them. Now, if we're worried about taxing all households, we could say, all right, we'll do it at a pension fund level and just say, all right, we're going to do a bail-in from the pension funds, but the bail-in is going to pay the government, who then distributes it as a bailout. If we could do that, I think that, one, is easier to administer, and two, has less risk of failure if one of our bail-ins gets stuck on the chain at a financial institution. All right, now, that being said, here's where I'll backtrack on my point. what I just said makes a lot of sense in my kind of fantasy land where politics doesn't exist. And so to their other principle about institutions, here's where bail-ins might make sense. When a bailout is not not politically feasible, we should do a bail-in, right? Those are the two choices. Those are the best choices. And if your institutions are set up where you can't politically do a bailout, then do a bail-in. Now, my bias in thinking about it from the US, like, we didn't care about national debt and our kind of bailouts in the last years. It's like flood money in, doesn't matter. And no one politically really, there was not a lot of pushback. And so you might say, yeah, but what about this pushing it down generations? If there's two questions, one is, if you can't do the bailout because people don't want to push it down generations, do a bail-in. The harder question, and I don't know the answer, is if the only way to do the bailout is to push it down to future generations, because you can't do that last thing I said, where you tax the households and the pensions, do you do a bail-in? So which is worse, a complicated bail-in or a kick it down the road bailout? That is a really hard question to answer. My worry is, in a crisis, you will never have time to answer that question, right? So we should be thinking about that when things are calm, planning for the next bail-in, bail-out world. My intuition is still the bailout is going to be so much cheaper that it's worth it. But again, if it's not politically feasible, go for the bail-in, right? The bail-in is expensive. The bailout kicks things down the road, but in some places might be more politically problematic. And again, it's going to be either way depending on the jurisdiction. So that's where I say I backtrack a little bit. It might be the right solution for some institutions in some jurisdictions. That's my main pushback. Again, I agree with everything leading up to the bail-in, bail-out balance, because I think they've really hit on an important point about bankruptcy law and about the principles we want to think about in this situation. So thanks, and I'll hand it over, I guess, to Aurelio.
Okay, so thank you so much to the organizers for the opportunity to be here today. Also, I would like to congratulate the authors for the fantastic paper. So Kristin, thank you so much for the opportunity to commend your paper, and congratulations. I think it was a very insightful paper because many authors, including myself, were a bit biased toward using bankruptcy law, using corporate workouts. And that's why when I first read your paper, I was kind of fascinated and said, hey, actually, I do agree with the main point of the paper, which is bankruptcy law is very costly. But then I thought, well, are bail-ins, are bailouts the right solution? And after reading the paper, particularly the table comparing the different public policy responses, I found that bankruptcy law can actually help in, for example, distinguishing between viable and non-viable firms. So that's why maybe this is something that you guys highlight also in the paper. But I think that this is actually a very important function, because bankruptcy law will ultimately provide an exit to viable companies, either because the creditors have approved their organization plan or because the court has approved a plan that meets certain requirements, such as the best interest of creditor test and many others, indirectly showing that the company is economically viable. So that's why, unless the bail-ins and bailouts are adopted for all types of firms and all types of industries, and I don't think that's the idea of the proposal of the paper, I think that's something that bankruptcy law does really well, or can do, especially in countries with well-functioning insolvency system, is to distinguish between viable and unviable firms, or eligible and non-eligible firms, if we want to frame it that way, for the purpose of having access to the bail-in, having access to the bailout. So that's why the insolvency system is not doing that job. That means that the regulators will need to do it. So that's why we may have to invest resources, and we can create some costs and some unintended consequences, even litigation, because we need to either decide ex ante the type of firms that are going to be eligible to the bail-in and the bailout, and that can create many problems. Actually, the paper mentions several examples about how to kind of deal with that. And for example, if you didn't have any default pre-COVID, so that's kind of one factor potentially showing that you deserve to be subject to the bail-in or bailout. But actually, some regulators are even, especially those providing financial support to financially distressed firms affected by COVID, are trying to regulate concepts such as viable firm or concepts such as revenues and operating expenses in many different ways. So that's why I think that from an ex-ante perspective, it's not very easy to define what we even mean by viable firm. So for example, the paper defines viability by comparing revenues with operating expenses, while other authors, for example, define viability by comparing going concern value with liquidation value. So it's not really clear. So that's why I think this is an important cost, and maybe in the future, litigation. And also from an ex-post perspective, you guys also mentioned in the paper that maybe we can impose some types of sanctions for misusing these provisions to have access to the bail-in, bailout. But I think that the paper undermines maybe the value bankruptcy law may be performing that function. And more importantly, if I'm not wrong, I think that the table comparing public policy solutions mentions that the bail out doesn't require any legal institutional resources, and the bail-in requires minimum resources. And in my view, I think, well, it really depends on how it is implemented. My main concern with the proposal is the actual implementation. So in terms of the implementation, I do think that some resources, legal and institutional resources, need to be used. It really depends on how, for example, the bail-in, the bailout is going to be implemented, because if the government just provides the funds to the banking sector and then the banks conduct the viability assessment, etc., of course, the cost will be reduced. But if we envision a government distinguishing the type of firm that need to be eligible, will have access to it, I think it will require a lot of resources. So that's why I would like to mention one additional cost of this bail-in, bailout solution, while also emphasizing maybe the value bankruptcy law on that. And also, if we look at some intermediate solution, kind of in the middle between the bankruptcy and the bail-in, bailout, I think that something that I would like also to hear your views is on the role of workouts. Actually, you wrote an excellent paper as well at the beginning of the pandemic about the importance of corporate workouts in dealing with COVID distress as well. But sometimes we mention, yeah, we need to use workouts, but the problem is that these workouts are not properly or actively promoted. So that's why if we really want to promote workouts, we need to do something else. Enacting guidelines. So like the London approach was very successful because the Bank of England was behind it. In Singapore, the Association of Banks of Singapore is behind it. So I think that we need central banks and regulators really doing something to promote that. Tax incentives to debtors for the haircuts, tax incentives for creditors also. And because I am still skeptical of the workouts, some banks might not want to cooperate, some creditors, maybe we can think about something, and I would like to hear your views on what the solution implemented in Asia after the Asian financial crisis in the 90s. So many countries in Asia have very bad and very inefficient insolvency frameworks. So that's why the quickest and most efficient solution was to just adopt enhanced workouts, which is basically an entirely out-of-court restructuring, but with maybe one or two features generally existing in insolvency law, such as a majority rule, for example, and also avoiding the use of courts. Instead, the stay, the automatic stay or the approval of the plan, etc., everything is going to be handled by the committee of creditors. So basically, we are internalizing the cost of managing the procedure. And this is, for example, something still existing in some countries, such as the Philippines. So, and of course, even if we adopt this enhanced workout, something that can be doable is also to adopt that in conjunction with some forms of bailout. So some kind of wage subsidies or government supported loans, even some authors such as Olivier Blanchard and others have proposed also that if private creditors have agreed a haircut, then public creditors should be subject to the same or even more, a higher haircut. So that's another possibility. And in any case, I think it's useful, and actually countries should take advantage of now that it's more politically feasible, I would say, to adopt insolvency reforms, because for some companies, as for example, Professor Casey also emphasized in his paper, and also other authors, for some specific companies, for individual financial distress, mainly large companies with financial creditors, the bankruptcy system can still be useful. Maybe something that we can also consider is whether the system works also for MSMEs. And something that I know that is not the scope of the paper, but I would like to hear your views as well, is that the paper focuses on saving viable businesses. But the truth is that many businesses are not viable. Many businesses, because of the pandemic, are going to become non-viable businesses. So how should we deal with that? Especially in countries, mainly in Europe, for example, where many countries even impose a duty to initiate insolvency proceedings. So how should we deal with insolvent but non-viable firms? So I think that the bankruptcy system still has a role to play in the context of liquidating non-viable firms. Maybe something that we can consider is whether just amending and improving the insolvency system for liquidations on a permanent basis, or something that, for example, Singapore has done, is to adopt a simplified insolvency program for MSMEs, basically that is going to have, it's going to be enacted for 6 months, at least so far. So maybe something that we can do to handle the wave of non-viable firms becoming insolvent because of the pandemic is also to enact some temporary frameworks to liquidate in an efficient manner non-viable firms and to provide an exit to these companies. So that's all from my side, but again, congratulations for the amazing paper, and thank you so much for the opportunity to discuss the paper.
Thank you, Aurelio. We have a number of questions for Kristin, and a few minutes to use them for that. Let me begin with one question that is actually directly following up on Aurelio's point, which is made by Harry Pandey. How about a hybrid model? Wouldn't you consider combining bail-in and bailouts with some use of the traditional bankruptcy procedure as a design approach?
Thanks, Amir. Shall I respond to that first and then a couple of comments on Tony and Aurelio?
Yeah, I think so, yeah.
That'd be great, thanks. So it's a great question, Harry. So maybe we didn't express this clearly enough in the paper, but we definitely still contemplate a role for the application of pre-pandemic bankruptcy law, so including throughout a period of a trading shutdown. So if you got a business that was non-viable prior to the onset of the pandemic, in our view, there'd be no reason not to, assuming capacity in the system, to treat that immediately. If you had a business that was thought to be viable at the onset of the pandemic and expected to be viable at the end of a lockdown period, but was expected to need some financial restructuring, we concede that you may well need to use a state-supplied procedure to impose a restructuring plan on creditors who won't agree to this consensually. So again, we thought bankruptcy law would be used for that, but we weren't sure it would be desirable to force debtors into that at the earliest opportunity, because the effect, and this goes to your point, Aurelio, of the lockdown on the viability of the business and the duration of the lockdown wouldn't be knowable at the outset. So we risked exposing debtors, imposing the costs of reorganization procedures on debtors who actually could achieve a consensual workout on the lifting of a lockdown restriction. Now, would we still make this claim today, knowing what we now know, which is not one lockdown, but 17? I think so, because in the paper, we say it's still hard for creditors midway through a lockdown to distinguish, again, drawing on the literature of others, between strategic and non-strategic defaults. And during a lockdown period, creditors are themselves likely to be under stress. And so it's the least likely time for them to agree to a consensual workout. So I think we still would have this view. So I agree, a hybrid model is what we advocate for, but we strongly argue against the use of bankruptcy law for the reasons that Tony summarized, and which are now also set out and expanded on some important points in a recent paper by Tony. We would argue against thinking about bankruptcy law as the default option for the treatment of newly distressed debtors at the beginning of a lockdown period. As to a hybrid a combination between bail-in and bail-out, I completely agree. You don't have to do, they're not one or the other, but in practice, we haven't observed many bail-ins. Yeah. Shall I just take a minute to respond to Tony and Aurelio's comments, Amir, if that's okay? I know we've only got 4 minutes to go.
Yeah, I mean, yeah, I think you've by now addressed in one way or another point that was made by Chen Lin. So I'll take that point as addressed, and yeah, go ahead and respond.
So these are really great comments, and thank you so much to both of you for spending so much time thinking about the paper. So I agree with everything that Tony said at the outset of his comments about the utility of and limitations of using bankruptcy law. On bail-in and the difficulties of operationalizing this. So this is something we've discussed as an author team a lot. And there's a difference of opinion between the author team as to the relative desirability of bail-ins and bail-outs. But those of us who favor intuitively find bail-ins more attractive. I at least intuitively find bail-ins more attractive for the reason that they involve a one-time allocation rather than, as Tony termed it, a kicking down the road. But I think we must concede the practical difficulties of operationalizing it in a way that exhibits fidelity to our principles, and in particular ensures that transfers are from the less financially constrained to the more financially constrained. And I think in the paper, I was keen to not overemphasize the legal challenges associated with implementing a bail-in, because I do think they're sometimes exaggerated. It is possible to lawfully design a mandatory bail-in. It's not that it will necessarily be unconstitutional or violate fundamental principles to do so, but I think perhaps we went too far the other way in the paper, that we understate the difficulties of this. And I take Aurelio's point that there will be non-trivial costs associated with policing the appropriateness of the design of the bail-in in circumstances where, as Tony says, it's probably going to have a blanket characteristic because it can't be case by case. So once it has a blanket characteristic, you're then going to have a real question about proportionality and compliance with your fundamental constitutional protections for property interests. On viability, of course, in principle, I agree bankruptcy laws do, if well designed and well implemented, can help to perform this filtering function. I'm very skeptical that bankruptcy laws could have performed this function if widely used at the onset of the pandemic for a bundle of reasons. I do think our alternative policies do prolong the life of some non-viable businesses, but I don't know that bankruptcy law would have done a whole lot better if all those debtors were subjected to mass treatment. On workouts by the system, on workout, so there are lots of interesting historical models to look at in cases of extreme shock. The workout models that you refer to, Aurelio, are basically, as I understand it, bank-led initiatives in which, through central bank guidance, banks are encouraged to contemplate workouts and are given concessions on classification norms that enable them to do so. You can do that, central banks can do that, or at least in some jurisdictions they can do that, but it creates problems for the financial system and for the viability of banks. And then you have to have a second system in place to deal with the allocation of the losses that the banks incur. So I don't think there's an easy solution. But I'm less excited than you are, Aurelio, about the prospect of mid-pandemic bankruptcy reforms. We've seen a lot of this, and my overall impression is it's concerning. So in the UK, for example, there are a number of features of the 2020 reform that I don't think are necessarily optimally designed. And they've been designed in the way that they have because they were delivered mid-pandemic. That's the end of my speech. And thank you so much to both of you for fantastic comments.